of the lease, did you get that?
No, not fully.
Okay, well, how did you conclude that the lease was terminated?
If there's no
With
production
what-
from the lands under the terms of the lease, then they expire by their terms.
Isn't it true that under the terms of the lease, there's also a procedure that must be implemented to follow proper procedure of a termination of a lease?
What procedure?
The grounds is that a legal owner of the mineral has to be present to terminate the lease. Alpha doesn't have the grounds, or Landman does not have the grounds, nor does the division have the grounds to terminate a lease without due process. So I'm trying to figure out how you concluded that a lease was terminated through proper procedure when there's terms under the lease that must be followed. And if they're not followed, like a 30-day notification of
I'm going to
an error.
I object to this question. Line of questioning right here. First of all, there's no.
I'm not seeing how did he get to the termination?
Mr. Samaniego, hold on. Mr. Samaniego, hold on now, okay? So there's an objection because right now you're basically testifying and you're not under oath. You have a witness here that you can ask questions to, and you started doing that by asking him valid questions, but now you're alleging that the terms of the lease were not followed and that the cancellation is not proper, but you're testifying now. So if you want me to put you under oath, I can do that, but it'll be under penalty of perjury. And this witness here, at this moment now, you have the opportunity to cross-examine him. So please continue asking him just questions and make them simple questions, not compound questions, so the witness can answer you fully. Go ahead.
I'm just trying to figure out what evidence did Mr. Kaufman have for him to for his conclusion that the lease is terminated.
Perfect. That's a good question. That's enough. Mr. Kaufman, answer the question, please.
There's an implied duty in oil and gas leases to produce from the lands. And if there's no production from the lands, then the leases expire by their own terms.
Does that mean that it's an automatic termination, or does that just mean that a termination can be implemented?
Depending on the lease, but automatic.
Okay, so right there you just said depending on the lease. You just said depending on the lease.
Objection, that's not a question.
Let's go easy on the objections, Mr. Savage. You have a witness here who sounds like he knows what he's doing.
Thank you.
And Mr. Samaniego is trying to ask questions, and he's doing it his best. So I'm going to ask the witness just to try to cooperate with the party who's asking the questions. So I think the question, Mr. Kaufman, is, how do you know that the lease has terminated? And you said it's by the terms of the lease as an implied duty to produce. So are you saying that there has been no production? Is that what you're saying, Mr. Kaufman?
Correct.
And do you know anything more about that? Like, how long has there been no production? Or so how have you concluded that the lease has terminated based on lack of production?
Because we've taken new leases that cover the same spacing unit that the Sake well previously produced from.
Ms. Samaniego, did you hear that?
Yes. I would like to also ask Mr. Kaufman, when did you last review American's production?
Personally, probably at our last hearing, but I could pull it up very quickly.
Okay.
So, Mr. Kaufman, I have a question for you. You said that there were new leases now?
Yes, sir.
Can you explain what you mean by that and say it in terms that Mr. Samaniego can understand as well?
So once the Sake well leases expired, the interest reverted back to the mineral owner. And we took new leases from those mineral owners. And have
And
those.
it's for, okay, Mr. Kaufman, and it's for the same interest that AER is saying that they have?
Correct. I'm not sure exactly what leases they're purporting to own in, but we have the majority of the north half of Section 17 leased.
And is that where the well bore interest at AER, that's where it's located?
Yes, sir.
All right.
And it does
Okay.
look like the last production for that well was in 2010.
Okay. All right. So, Mr. Samaniego, I'm not giving you advice, and I believe you have an attorney. I forgot his name, but I believe you have an attorney who's helping you with the appeal on that other case out of the 5th District. What's his name?
Mr. Candelaria?
That's it, Mr. Candelaria. I would talk to him about this, but from the evidence that I've heard today,
I haven't presented my evidence. You've gone off of hearsay, and they have not presented evidence to justify throwing American out or silencing American. Okay, he said that he was going to look into, and we're still waiting on him to present the evidence that he said that he was going to quickly get. Aside from that, under statute 71-3 through 5, the lease doesn't automatically terminate, and that's through state law. The division does not have jurisdiction to terminate it, nor does a good story have justification to terminate it. The lease and Americans' core elective rights are protected, and the division must protect Americans' core elective rights from being infringed upon and from being silenced. There has been no evidence presented to terminate the lease, and American has been actively filing and testing on the well, and filed filings on the well to work over the well and to re-enter. American has been in compliance since they took over the operations of the wells since January, February, and have been in compliance up to date. For there to be false statements of non-production and non-activity is false. Okay, it's a way to sway the division, and it's unjust to go off of hearsay.
All right. Thank you, Mr. Samaniego. Okay. From the evidence that I have heard, and unfortunately, Mr. Samaniego, you're not under oath. You're not a witness. What you say is not evidence. The evidence I have before me says that you do not have a interest in these 4 cases. So I'm going to...
No evidence is presented to you. It's not admissible evidence if it's hearsay. Hearsay is not admissible evidence. You can hear it all day long, but it's not admissible evidence.
Mr. Samaniego, unfortunately. Mr. Samaniego, if you read the rules of administrative hearings, you'll understand that hearsay is admissible when it's reliable and relevant. In this case, it's not hearsay, and it is reliable. So I am granting that motion to strike your entries of appearance in these 4 cases.
Please have the reliable evidence submitted to me.
Mr. Samaniego, please. Mr. Samaniego, I'm done listening to you for today in these 4 cases. If you're in another case, I'll hear you in that case. But Mr. Savage, it is noon now, and I'm sure you'd like to present these 3 cases by affidavit so you can leave. Do you have other cases after this?
One more, just for an appearance.
Why don't you? Oh, that's
Yeah, so, yeah.
Right. So why don't you present your 3 cases today?
Okay.
Mr. Anderson's objection is maintained in that case, as I already said. So go ahead and 25495, 97, and 98.
Okay, thank you, Mr. Hearing Examiner. These 3 cases cover lands in sections 17 and 18, Township 22 South, Range 27 East, in Eddy County, New Mexico. The landman for these cases is John Kaufman, and the geologist is Jason McLean. Both persons have testified before the division as expert witnesses, and their credentials have been accepted as a matter of record. In these cases, the combined cases, Alpha seeks to pool all uncommitted interests in and develop the bone spring formation underlying the two sections, section 17 and 18. In case 25495, Alpha seeks order pooling the north half of section 17 and 18 as a unit. In case 25497, Alpha seeks to pool the south half of the sections. And in case 25498, Alpha seeks to pool the north south half of the sections. Each unit will be dedicated to the two of the Hollywood star wells, respectively. Orientation of the units are laid down east to west, and the wells have standard locations. Mr. Kaufman's Exhibit A in each case includes his landman statement, the C-102s, and ownership breakdown, the well proposal letter with AFEs, and the chronology of contacts. Mr. McLean's Exhibit B in each case includes nine geological exhibits that provide structure maps, stratigraphic cross sections, isochore analysis, gun barrel views, and stress analysis. Exhibit B in each case provides the self-affirmed statement confirming the mailing of notice, letters, and notice by publication. Notice was timely mailed on July 17, 2025, and timely published on July 19, 2025. Mr. Examiner, at this time, I move that Exhibits A, B, and C and all sub-exhibits be accepted into the record for these three cases, 25495, 25497, and 25498, and that the cases be taken under advisement. Counsel and witnesses are available for questions.
Your exhibits are admitted without objection in these three cases. I turn to Mr. Fordyce.
Yeah, I have just a quick clarifying question for the landman, Mr. Kaufman.
He's already under oath. Go right ahead.
Mr. Kaufman, in case 25495 on page 35 of 381, at the bottom half of that page, it starts with a pooling list recapitulation. Are you seeing that?
Yes, sir.
I think it's safe to assume that Alpha is not pooling Alpha, but everyone else on the list.
That's correct.
And prior to this, this land is made up of separate 40-acre tracts, and it's a rather extensive list. So if you were to follow the standard yellow highlighting, we'd have a page and a half of yellow. So if I understand correctly.
Yes, sir.
So I believe the division can accept this format that's a little non-standard, and I don't have any further questions for these cases, Mr. Hearing Examiner.
Okay, so nothing needs to be corrected?
No, sir, Mr. Hearing Examiner.
Okay, very good. All right, so thank you very much, Mr. Savage. These three cases will be taken under advisement, and we will hear this other case as a status conference on the 21st.
Thank you.
Now, I see that we have about 6 more cases to go. Let's power through unless someone really doesn't want to, and I think you all do. Okay, now I believe you only have one case, Ms. Vance, and it's Ms. Hardy and Ms. McLean who have the bulk of the other cases. So why don't you do your case so you can go? And I'm going to call your case, and that is case number. Page. That would be case number 25510. It's number 50 on the docket.
Good afternoon, Mr. Hearing Examiner. Paula Vance with the Santa Fe office of Holland and Hart on behalf of the applicant Chevron USA Inc. I don't believe there are any other parties. So in this case, Chevron is seeking approval for pooling. I will note that there is a depth severance related to this case, and I'll give just a very brief history on this. There is a pooling order for the lower half of the bone spring. In this case, we're pooling the first bone spring. So the pooling order for the base of the first bone spring to the top of the wolf camp is Division Order RTAC 769. I did file case number 25118 previously, and it actually was to reopen that case and pool the entirety of the Bone Spring because the interests we're pooling are the same interests in the same percentage. So I thought that I would try to consolidate, but it's sort of my understanding from Mr. McClure that we need to have two separate cases. So all that said, the case order for 25118 is still pending. We filed this to just pull the first Bone Spring. So in this case, Chevron is pulling the uncommitted interest from the top of the Bone Spring Formation to the top of the second Bone Spring Sandstone, and that is in the east half of sections 14 and 23, Township 24 South, Range 31 East, Eddy County, New Mexico, and initially dedicate this spacing unit to the S&D or sand dunes 1423 FedCom 220H, 222H, 223H, and 224H. All of these wells have a non-standard well location and approved orders associated with them. And then the 223H is the proximity well, creating the enlarged spacing unit for this, for the first Bone Spring here. We've included a copy of the application along with the compulsory pooling checklist, as well as the self-affirmed statements of our landman, Douglas Crawford, and our geologist, Andrew Roick. Mr. Roick has not previously testified before. We have included a copy of his resume. And then other than that, we have included all of the standard sub-exhibits along with the type log for the Striker 2 SWD number 1, which was used in for the legal description of the top of the first Bone Spring, or the top of the first Bone Spring and to the top of the second, I'm sorry, the top of the Bone Spring Formation to the top of the second Bone Spring Sandstone. Additionally, I have included a self-affirmed statement from myself with the sample letter that was timely mailed on July 18th, 2025, and then the affidavit of notice of publication that was timely published on July 19th, 2025. And unless there are any questions, I would ask that the exhibits and sub-exhibits be admitted into the record and that this case be taken under advisement at this time.
Thank you. Admitted without objection. Mr. Fordyce?
I have a question for the landman, Mr. Crawford, or Mr. Crawford, I believe.
Okay.
Yeah.
Do we have that person handy?
He should be online. He has been listening all morning. I know that.
Yes, I am.
There he is. That's Mr. Crawford. He should be.
Oh, thank you.
Sorry.
Mr. Crawford, would you raise your right hand, please? Do you swear or affirm under penalty of perjury that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you. Have you previously been recognized as an expert by this division?
Yes, I have.
In what field?
Petroleum land.
Perfect. Mr. Fordyce?
Mr. Crawford, I'm looking at page, I believe it's exhibit C2 on page 17 of 36 that indicates that Chevron is asking to pool EOG resources as record title owner.
What was
That
the
is correct.
page?
Page 17. Is that correct, Mr. Crawford? Asking to pool EOG resources as record title owner?
Yes.
Okay. If we could look at page 35, which is the postal delivery report, I don't see any notice to EOG. Was EOG noticed of this case in this hearing and those requirements for pooling?
It does not appear that they were noticed.
And they were required notice, correct?
I would believe that would be correct.
So it seems like we may have to continue this case to cure notice to EOG is what it seems like to me.
That sounds correct. And I can talk with Mr. Crawford offline, but if Chevron's needing to pull them, then we'll need to notice them. So
So then September 11th.
yes, please.
All right. All right. Thank you, Mr. Fordyce. Good catch. 9/11, really? Great. Okay. I just realized that. All right. Is that all, Miss Vance?
That's all I have unless there are any other questions.
Okay. Your exhibits are admitted into evidence. We'll just need for you to show us that you've noticed this.
We will send it out, overnight it today.
Okay, let's move on. The rest of these cases are all Miss Hardy's and Miss McLean's. Do you want to take them in any particular order, or is it fine to do it in the order they are?
The order they are, because I'm doing
Okay, perfect.
25500.
Fantastic. I'm going to call number 45 on the docket. That is 25500.
Yes, Jackie McLean on behalf of Permian Resources,
Any other parties, Miss McLean?
and not in this case.
Then go right ahead.
Thank you. In case number 25500, Permian Resources seeks an order pulling all uncommitted interest in the Wolfcamp Formation, underlying a 245.91 acre, more or less, standard horizontal spacing unit comprised of the south half of sections 31 and 32, Township 19 South, Range 28 East in Eddy County. And this unit will be dedicated to the Dakota 32 FedCom wells. And the exhibits were submitted timely for this case and include the land testimony and corresponding exhibits of Ryan Curry, who has been previously admitted to testify as an expert in petroleum land matters before the division, geology testimony and exhibits from Chris Canton, who has also previously been admitted to testify as an expert geologist before the division. Finally, notice testimony along with copies of the notice letter, which was sent to all interested parties on July 11th, 2025. And it includes an affidavit of publication for July 22nd, 2025. And I ask that the exhibits be admitted for case number 25500 and that the case be taken under advisement.
Exhibits admitted without objection. Mr. Fordyce?
Yes, can everyone still hear me? My internet seems to be acting up.
Yes, we can hear you.
Okay, great, thank you. Yes, for case 25500, there seems to be some errors in the application checklist starting on page 2 of 51.
Okay.
The first item is, this is case 25500. It has listed case 25512. The second item in the proximity tracks section, it should read within 330 foot of the quarter-to-quarter section line separating the north half, and south half, rather than the south half, north half. And in addition to that, the last item is in the description under wells for well number 1. The bottom hole location listed there is not even close. It's actually like 2,000 some foot from the south line in lot 3, I believe. So that needs to be corrected.
Yes, we can correct those. Those just seem like typos that we could just amend and submit. Is that correct?
Mr. Fordyce, do you want to further review once the corrections are made?
As long as those 3 items get corrected on this checklist, I would be good with that.
Okay, how long will it take for you to correct it?
I can do it today.
Today? Okay.
Yeah.
All right, so we'll give you by the close of business today to make these corrections, file an amended exhibit packet with the cover letter, and then we'll take this case under advisement once you do that.
Will do.
All right, thank you.
Thank you.
We're off the record in that case. Let's go to 46 on the docket. It is two cases joined together, 25502 and 25503.
Mr. Examiner, Dana Hardy with Hardy McLean on behalf of Permian Resources. And Ms. Kessler had entered an appearance for EOG, but was only monitoring these
Perfect,
cases.
thank you. Go right ahead.
Thank you. In case number 25502, Permian Resources seeks to pool interest in the Bone Spring underlying a 319.77 acre, more or less standard horizontal spacing unit comprised of the north half of section 24, township 20 south, range 26 east, and the north half equivalent of irregular section 19, township 20 south, range 27 east in Eddy County. In case number 25503, Permian seeks an order pooling uncommitted interest in the Bone Spring underlying a 319.88 acre standard horizontal unit comprised of the south half of the north half of section 24, township 20 south, range 26 east, and the south half north half equivalent of irregular section 19, township 20 south, range 27 east. These units will be dedicated to the Le Mans 24 State Com wells. Our exhibit packets include the self-affirmed statements of landman Ryan Curry and geologist Christopher Canton, both of whom have previously testified and been recognized as experts. Mr. Curry provides the standard land exhibits and Mr. Canton provides the standard geology exhibits. Notice was timely sent by certified mail on July 11th, 2025, and was timely published on July 19th, 2025. With that, I request that the exhibits be admitted and that these cases be taken under advisement.
Exhibits are admitted without objection. Mr. Fordyce?
I have no questions for these cases, Mr. Hearing Examiner.
May we take these under advisement?
We can take them under advisement.
Thank you. Let's move on to BTA Oil. These are two cases that are joined together, 25504 and 05.
Dana Hardy with Hardy McLean on behalf of BTA.
Go right ahead.
There are no other parties. In case number 25504, BTA seeks to pool uncommitted interest in the Pennsylvanian Shale Formation underlying a 320 acre standard horizontal unit comprised of the east half of the southwest quarter of section 9, the east half west half of section 16, and the east half northwest quarter of section 21, township 17 south, range 36 east in Lee County. In case number 25505, BTA seeks to pool uncommitted interest also in the Pennsylvanian Shale Formation underlying a 640 acre standard horizontal unit comprised of the east half southwest quarter and west half southeast quarter of section 21, the east half west half and west half east half of section 28, and the east half northwest quarter and west half northeast quarter of section 33, township 17 south, range 36 east. These units will be dedicated to the Vindicator Canyon 417H and 418H state unit com wells. Our exhibit packets include the self-affirmed statements of landman Willis Price and geologist J.T. Trong, both of whom have previously testified and been recognized as experts. The notice information is included in Exhibit C and shows that notice was timely sent by certified mail on July 15th and was timely published on July 22nd, 2025. With that, I request that the exhibits be admitted and that these cases be taken under advisement.
The exhibits are admitted without objection. Mr. Fordyce?
Excuse me, I have questions for the landman.
And who would that be, Ms.?
That is, Mr. Willis Price, and I believe he is online.
Yes, I'm here.
We don't see you. There we see you now. Okay, Mr. Price, please raise your right hand. You swear or affirm under penalty of perjury that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, I do.
Please spell your name.
WILLISPRICE.
Great. You can put your hand down. Thank you. You've been previously recognized as an expert before this division?
Yes, I have.
In what field?
Land.
Great. Mr. Fordyce?
Mr. Willis, I'm looking at exhibit maybe A3, but on page 14 of 100, showing the tracts of land and the recapitulation. And it looks like Texas Company Title has a working interest in Tract 1. And the recapitulation indicates that BTA is seeking to pool that particular party. Is that correct?
Yes, that is correct.
If we could go to page 17, there's another, I guess, format for describing the ownership. And I was just curious why that working interest that you're seeking to pool is not listed here.
Okay, on that exhibit, the tracks that are a part of the Vindicator unit are what this exhibit A3 is referring to. And that track is that you were describing is not in the Vindicator unit.
I would have a similar question for case 25505, and your explanation would be the same for that case?
Yes, sir.
Okay, no further questions then.
May we take these cases under
Thank you.
advisement?
We can take these cases under advisement, Mr. Hearing Examiner.
Fantastic. So now we have 2 cases left, and this would be number 51. And it looks like it's joined with 52, 25512 and 25513. I'm not sure what happened with 25511, but hopefully you'll explain that.
Yes. Dana Hardy with Hardy McLean on behalf of Permian Resources
Thank you.
and Ms.
Let's-
Kessler, and actually,
He's Aaron Savage appearing on behalf of Devon Energy Production Company, LP.
Thank you. And what were you going to say about Ms. Kessler?
the Ms. Kessler had entered an appearance in these as well, but does not object.
Great. And Mr. Savage, any objections?
No objections.
All right. What happened to 25511?
We continued that case because an interest owner requested the continuance for time to negotiate a JOA.
So if we hear these 2 cases today, then 25511 will not be joined with these cases anymore. So Mada'i, would you unjoin them, for lack of a better word? Okay, go right ahead.
Thank you. In case number 25512, Permian Resources seeks to pool uncommitted interest in the Bone Spring underlying a 634.96 acre, more or less standard horizontal unit comprised of the east half equivalent of irregular section 1 and the northeast quarter of section 12, township 21 south, range 34 east. In case number 25513, Permian Resources seeks to pool uncommitted interest in the Bone Spring underlying a 475.12 acre standard horizontal unit comprised of the west half equivalent of irregular section 1, township 21 south, range 34 east. The units will be dedicated to the Outland State Unit wells. Our exhibit packets include the self-affirmed statements of landman Reagan Armstrong and geologist Christopher Rudelhuber, both of whom have previously testified and been recognized as experts. Mr. Armstrong provides the standard land exhibits and Mr. Rudelhuber provides the standard geology exhibits. Notice was timely sent by certified mail on July 16th and was timely published on July 22nd, 2025. With that, I request that the exhibits be admitted into the record and that these 2 cases be taken under advisement.
Thank you. The exhibits are admitted without objection. Mr. Fordyce?
I have some questions for the landman.
Okay, sounds good. Ms. Vance?
It's related to the case that I just presented.
Oh. Okay.
If I can have a minute after Ms. Hardy's.
Take care of it after.
Thank
Okay, who's your landman?
It is Miss Reagan Armstrong.
Okay, and Mr. Anderson, I see your hand is up. Do you still have a question? Ms. Corral, do you know anything about Mr. Anderson's hand still being up?
Yeah, he does have a question.
Okay, we'll deal with it after these cases.
Okay.
Thank you. Okay, can we get this person,
I'm on.
I see you on, I just wanted you to be bigger.
Oh.
Perfect, thank you. Ms. Armstrong, would you please raise your right hand? Do you swear or affirm under penalty of perjury that the testimony you're about to give is the truth, the whole truth, nothing but the truth?
I do.
Please spell your name.
REAGANARMSTRONG.
And have you been previously recognized as an expert before this division?
Yes.
In what field?
Land.
Perfect. Mr. Fordyce?
Yeah, I'm looking at Exhibit A3 in case 25512, which is page 19 of 59.
Yes, sir.
On page 19, I see that there are 4 tracts of land that are illustrated, but below that, in the breakdown, there are 6 tracts of land that are being described. And kind of the same situation for 25513, where
So
there's five tracts of land illustrated, but only 3 tracts of land in the breakdown, which I'm a little confused by.
the top map is just to describe the leases and have those laid out. So each track is just associated with the lease that goes over the portion of land, and then below, it's broken out by ownership, and I listed the legal description for each of those ownership breakdowns.
That's the same thing in 25513, I would assume then?
Yes, sir.
Okay. Very good. Thank you for your explanation. I have no further questions.
May we take
Thank
this
you.
case, may we take these cases under advisement?
We can take these cases under advisement, Mr. Hearing Examiner.
Okay, thank you, Mr. Fordyce. That concludes our regular business today, but Ms. Vance has something to say, and so does Mr. Anderson.
Yes, so in case number 25510, I was hoping if you could recall it, because actually we don't need to pool EOG.
Okay.
They signed the comm agreement. I just confirmed that with my landman.
Okay.
So what I would request is to just file a revised hearing packet, unhighlighting, yes, an amended hearing packet where we unhighlight that party because we don't need to pool them.
All right, Mr. Fordyce, you've heard Ms. Vance. What do you say?
If there's no need to pool EOG, they've signed a comm agreement, and we just need to revise that. I'm good with that.
Okay, so when would you be able to have a revised exhibit packet?
Today.
Today. Okay, so we'll leave the record open for the rest of today. We'll take the case under advisement. It doesn't have to be moved to 9/11. And I'm assuming that you're going to submit something that says that. I mean,
If the division wants some sort of proof, I can provide the signed page of the CA if
Perfect.
that works.
that'd be great. Yes,
Okay.
include that with your cover page, explaining what you're doing so that we can take it under advisement.
I will do that.
All right. Mr. Anderson, did you have a question? Mada E, are you sure he has a question?
Yes, he did. I just,
Is he still there?
yes, I see him here. I think he's trying to unmute.
Ms. Pena, was there something else? No, okay. Well, Mr. Anderson, we can't hear you, so why don't you send an email to Ms. Corral and I'll try to answer
Hello?
it. Yes,
Hello?
I hear you. Mhm.
Mr. Examiner, what I wanted to say is, I heard everything. I was there at 0900 hours, and I mean, I heard the whole hearing, and I wanted to object to but I couldn't get through. So I had to hang up and I had to call back, and that's the only way that I got through. And so I wanted to object to those 4 things because we're our land is in all 4 of those cases, even though that we don't own in those other 3 cases. That I wanted to know, how did it affect? I wanted to ask Mr. Kaufman, how does that, or Alpha, how does that affect our area, our land?
Okay, so
So-
let me go to Mr. Savage. Is your microphone on? All right, thank you. Go ahead.
So if I heard the question correctly, how does the objection affect his unit?
He stated, although it's not evidence, he stated that his land is part of all 4 cases.
So the evidence we presented and shown shows that he only owns in one particular unit and one particular case, and no other evidence has been submitted to counter that evidence. So I would say that, you know, we made a ruling on it. So that I think the ruling should be sustained, except for, you know, possibly of a motion to address it otherwise.
So Mr. Anderson, hold on. The evidence before me, based on the landman's testimony, was that your ownership interest only affects 1 case, not all 4 cases.
Right. But my question, and I objected that because my question was, how does all of those other cases, even in the Pooler, it states that that all of those all of those areas are right there in the same area. So I'm trying to see, how does that affect our area?
Mr. Anderson, my suggestion to you is that you hire an attorney who deals with oil and gas matters, because it's not a question that I can answer, and it's not a question that opposing counsel who represents Alpha can answer for you either. The evidence showed that your interest was confined to 1 case only. So an objection and an entry of appearance in the other 3 cases was not proper. So I'm signing an order later today to remove your entry of appearance in those 3 cases, but you still maintain a entry of appearance and an objection in the case ending in 9-6. Ms. Corral is sending you a link so that you can access the imaging system and see what documents are filed in that case. You can review them and you can give them to the attorney who represents you. But at this point, I can't give you any more advice.
Okay, no problem. I thank you. Thank you.
And we'll see you on the 21st when the case that you are involved with is called for a status conference. You will receive the docket ahead of time, so you'll know what position that case is.
Okay, I appreciate it. Thank you.
Thank you, Mr. Anderson.
Thank you.
We're off the record.
All right.